I want to thank everyone for joining us. We apologize for the delay. The Democrats have an important caucus they're at, or conference they're at, and we had some technical difficulties here. We'll now, the chair now recommend himself for an opening statement. Alvin Bragg's prosecution of President Trump is lawfare at its worst. The New York County District Attorney's Office began investigating President Trump in 2018. Southern District of New York months later concluded its investigation into the payments by Michael Cohen and determined no charges should be brought against President Trump. While this was going on, Alvin Bragg was running for the job. While on the campaign trail, Mr. Bragg boasted about the number of times he had already sued President Trump. In January 2021, Mr. Bragg stated, "I'm the candidate in the race who has the experience with Donald Trump," close quote. He said that it'd be hard to argue with the fact that any case against President Trump would be the most important, most high-profile case. Mr. Bragg won and took office in January 2022. A few weeks after taking office, he told one of his prosecutors, Mark Pomerantz, quote, he could not see a world in which he would indict President Trump and call Michael Cohen as a prosecution witness. That's right. After campaigning on going after the former president, Bragg gets into office and realizes the case against President Trump is ridiculous. That is why the Southern District of New York didn't bring it. It's why his predecessor, Cy Vance, didn't bring it. Why did Bragg change his mind? Mark Pomerantz, Special Assistant District Attorney, resigned in protest, and he and his fellow Assistant District Attorney, Kerry Dunn, leaked their resignation letter to the New York Times. After that, the left began the pressure campaign on Alvin Bragg, and suddenly the zombie case was resurrected. One of the first things Alvin Bragg did was hire Matthew Colangelo, a top official in the Biden Justice Department who had a history of taking on President Trump and his family's businesses. It's also interesting to note who Mr. Colangelo listed as his references when he applied for the job at the Justice Department. He listed Tom Perez, former DNC chair, and Jeff Zients, who is now President Biden's chief of staff. That's right. The head of the DNC and the Biden White House chief of staff, those were his references. That's the guy who went to work to be the lead prosecutor on the case against President Trump. Alvin Bragg, Matthew Colangelo picked their target, searched for a crime, and then they prosecuted President Trump. The partisan DA that campaigned on going after President Trump, whose newly hired lead prosecutor for the case also had a history of taking on President Trump, also had their case in front of a partisan judge. A judge who donated to President Biden, who imposed a gag order on President Trump, who told the jury they didn't need to reach a unanimous decision, and prevented one of our witnesses today, Mr. Smith, an expert on campaign finance, from giving real testimony to the court. Today, Mr. Smith will be given an opportunity to tell Congress and tell the country what he wasn't permitted to tell the court, what he wasn't permitted to tell the jury. Remember, Bragg and Colangelo bootstrapped charges that are normally misdemeanors to some underlying crime to make the charges a felony. But what was the underlying crime? Prosecutors didn't reveal that until after the trial began. Mr. Colangelo, in his opening statement, accused President Trump of violating the Federal Elections Campaign Act. But the problem is, in the plain reading of that act, doesn't support the indictment or the verdict. As Commissioner Smith stated, allowing this prosecution to go forward and the ultimate jury decision threaten the enforcement procedures established by Congress under the act and stretch the meaning of the statute in such a way as to threaten due process of law. Although Judge Merchan wouldn't permit the leading expert on campaign finance to provide this testimony, he did let someone else speak in the court on this issue and others, Michael Cohen. Michael Cohen, a convicted perjurer, someone even his former lawyer said you couldn't trust. Michael Cohen, who lied to Congress, lied to the FBI, and lied to the court. It's not often you have a witness that can lie to all three branches of government and then become the star witness in the prosecution of a former president. But that's exactly what took place in New York. It is clear Manhattan District Judge Juan Merchan's decisions, guided by political bias, unfairly prejudiced the outcome of the trial and violated President Trump's due process rights. Bragg's prosecution of President Trump, with the help of Judge Merchan, opened the door for politically motivated prosecutions, and it will not be easy to undo the damage that's already been done. As we have seen, other ambitious prosecutors have followed Bragg's lead and pursued politically motivated indictments against the former president. Rather than debate political opponents on substance, the Democrats' strategy to win the 2024 election is through the use of partisan, lawfare tactics. These politically motivated local prosecutions raise substantial federal interest and potential collusion between federal and state authorities. And that is precisely why we are here today. Alvin Bragg's prosecution of President Trump was personal, it was based on politics, and it was wrong. Back, Professor Smith, in your opening, in your written testimony, you said that the lead prosecutor, Matthew Colangelo, in his opening statement in the court, accused President Trump of violating the Federal Election Campaign Act. But the FEC didn't bring charges, I think you've said a couple times. Is that true?
That's correct.
And the Department of Justice didn't bring charges.
That's correct.
And if President Trump's campaign had paid for it, it wouldn't have been reported until after the election. Is that right?
That's correct.
And did President Trump's campaign have the money to pay for it?
Yes, they had plenty of money.
And like $7-8 million bucks still on hand on election day, I think, right?
Yes.
And certainly President Trump had the money to pay for it. He's not.
Yes, he'd already spent over $60 million on it.
Yeah, he had. So they'd already done that. Was it a political contribution?
No, I do not believe so for reasons stated. I can elaborate on those now, but it's,
Not only do you not believe so, their star witness didn't believe so. Michael Cohen said he was working clear back in 2011 to deal with this Miss Daniels making the allegations and wouldn't make this public, and he was doing it for other reasons. Isn't that correct?
Yes, they had been concerned about Daniels for a long time and keeping her quiet.
So the obligation wasn't caused by President Trump's candidacy for president of the United States. Is that right?
No, it was not.
Okay, Mr. Fahey, in your written testimony, you said one of the most alarming aspects of the case is that the fraud, quote, fraud, did not involve anyone losing money or even being harmed in any way. To the extent that the ledger entries were inaccurate, they were entered into the books of a private company that understood what they were for. It is unheard of for a fraud case to be brought where no losses were suffered. So there weren't any losses in this case at all, were there?
Yeah, that's what makes this so remarkable. And just, I can't even imagine someone bringing a fraud case to the United States Attorney's Office where nobody lost money, there were no victims, and no one was worse off at the end of it. It just makes it laughable, even before you get to steps 2 through probably 20 that make this case really absurd to have been brought to begin with.
It wasn't a contribution. If it was a contribution, it wouldn't have been reported until after the election, and no one suffered any losses, and yet they bring this charge against President Trump. I find that just amazing. If that's not political motivation, I don't know, because what other motivation could there be?
It's really almost inarguable at this point that the motivation for this case was political. It's really, I've never heard a serious argument that it should have been prosecuted otherwise. I know Mr. Wu might have one, but I just haven't heard that, because it seems political from the inception all the way to the end.
Yeah. Wasn't a contribution, wouldn't have been reported even if it was, if they paid it out of the campaign. No one suffered loss, and yet there was some kind of conspiracy to impact an election. But that's not the worst of it. The worst of it is they didn't tell the defendant what the crime was he was being charged with. Isn't that right, Judge?
That's correct. Right from the indictment, Donald Trump was charged with falsifying business records. To elevate that crime to a felony, he had to be concealing or committing other crimes.
When did the defendant in this trial, in this case, learn what he was being charged with?
At the end of the trial.
At the end of the trial. That's not supposed to happen in America, is it, Judge?
No, that is illegal.
So not only did he not know what he's being charged with, at the end of the trial, when he learned what it was, the judge also told the jury, oh, you don't have to be unanimous in finding what we just discovered the charge actually was.
That's an extraordinarily egregious error to tell a jury they don't have to be unanimous. And I might add, by the way, those charges, the 3 additional ones, were never specified. They're described generally, so we don't know what exactly the jury thought was the illegality that was committed by Donald Trump. We have a very inspecific verdict.
Campaign finance expert says it wasn't a contribution. And even if it was a contribution, if they treated it as a contribution, paid it out of the campaign, it wouldn't have been reported until after the election, so there's no conspiracy to influence the election. No one suffered any harm or fraud in the initial case, former prosecutor tells us, and the judge tells us that the defendant didn't know what he was charged with until the end of the trial, and the judge gave instructions to the jury, never mind the fact the judge should have recused himself, which you point out in your written testimony, Judge. The judge didn't tell the jury, or told the jury you don't have to be unanimous. But the real thing here is the opportunity cost. And you raised this in your testimony, Mr. Fahey. The opportunity cost. When Alvin Bragg did the day 1 memo, says we are not going to charge all these felonies, we're going to bring them down to misdemeanors and let the bad guys roam the streets of New York. How that squares with what happened here, That to me is the real issue. That's the issue that most Americans see, like, we're going to do this to the former president of the United States, meanwhile, take felony charges against really bad guys on the street and bring them down to misdemeanors. That's the opportunity cost here, I believe, in Manhattan. You get the last word, Mr. Fahey.
Yeah, exactly. When you're letting carjackers out on bail or illegal immigrants that assault police officers aren't getting prosecuted, but this is the way you're using your time, in addition to the fact you run on a soft on crime policy and then you take the most creative, aggressive approach to this crime, it's hard to argue it's anything other than a political motivation.
Chair now recognizes the gentlelady from Texas.
Okay, I got a lot of ground to cover. I do want to clarify, Mr. Fahey, when you consistently talk about NY or New York crime, you're speaking in an opinionated stance. You're not speaking from a place of fact, correct?
No, I'm speaking from a place of facts.
Okay, well, let me clarify for you. Thank you so much. I'm reclaiming my time. Let me clarify for you that NYPD puts out reports. And in April, it said overall index crime across New York City dropped another 4.9%. As it relates to May, the report says overall index crime across New York dropped another 2.4%, and June's report hasn't come out. I would ask for unanimous consent to enter this into the record. Now, moving on, I just want to level set because I feel as if some people don't understand how government works, and I don't know how they got to Congress. So, Mr. Wu, I'm gonna need you to help me out because I don't know that I trust that other people will know the answers to these questions. Number one, how many branches of government do we have?
3.
3, okay, sounds good. So, can you name them for me?
Legislative, judiciary, and executive.
Very good. Okay, so currently, I think that I serve in the legislative branch. Would you agree?
I agree.
Okay, fine. Can you tell me when somebody goes to court, such as a criminal convicted of 34 felony counts, state court in New York, would that be the legislative people or judicial people?
Well, it's really the executive that's prosecuting, and then it's within the judiciary to run the trial properly.
Okay, very good. So, judiciary. So typically, if someone has an issue with, say, what happens in court, do they then somehow hop from state court all the way to the federal legislative branch, or is there a different process in which you are supposed to be able to explain any issues you may have?
The process would be the judicial appellate process, holding aside the issue of state versus federal.
Oh, interesting. Okay. All right. So normally people don't get convicted on a state level and somehow end up litigating the issue on the federal level in the legislative branch. Is that correct?
Yes.
Okay. All right. So something is different about what's going on today. I just wanted to clarify because I thought I was living in the upside down for a second. Now, I want to move on and talk about how someone is prosecuted. Currently, because under Project 2025, we'll get there, there will be a different way to prosecute people. But currently, it is my understanding, and I only kind of went to law school, passed a couple of bar exams, and practiced on the state and federal levels, but just clarify for me, when someone goes in to be prosecuted, is it, say, the President of the United States that somehow becomes the state prosecutor in New York?
Oh, absolutely not.
Absolutely not, because he's the executor, huh? That's that other branch.
Correct.
That's the, okay. All right, so you have this prosecutor, and in this case, it's Alvin Bragg, who was duly elected, correct?
Correct.
Not appointed by the president, correct?
Right.
Duly elected by the citizens in his jurisdiction, right?
Right.
So he's elected, and usually there's some sort of an investigation that takes place, correct?
Prior to his election?
No. With a case, I'm sorry.
Yes,
I've
correct.
moved on.
Yes.
All right. So the very first part of a case is that we go through an investigation. After that investigation, then the prosecutor usually has what we would consider to be some sort of prosecutorial discretion as to whether or not they want to go forward, correct?
Correct.
All right. And then they use that discretion, but then when it's somebody that is facing a felony amount of time, which is usually in most states over a year, then they have to present it to a grand jury. Is that right?
That's right.
Now, a grand jury is comprised of citizens, correct?
Correct.
U.S. citizens from that area, correct?
Right.
Okay, so they have to come to the conclusion that they are going to issue what we call a true bill, correct?
Correct.
All right, so then we have an indictment. And then there's pretrial motions, there's pretrial hearings, all kinds of stuff, right?
Right.
All right, and then ultimately, depending on where you are, you have the opportunity to say, hey, I want a jury trial, correct?
Correct.
And a jury trial is comprised of U.S. citizens again, right?
Right.
Okay, very good. All right, so can you tell me so far if all of this took place in the case in New York?
Yes, it did.
Oh, okay. All right, so you get to trial. Now, when you show up to trial and you're facing a felony amount of time, as a defendant, are you not entitled to an attorney?
Yes, you are.
And your attorney is allowed to pick the jury, they're allowed to present evidence, and ultimately, it is a jury of your peers who decides whether or not you are guilty or not, correct?
Correct.
And in this case,
the
30
has the judge involved too.
And in this case, they found him guilty not once, not twice, not 3 times, not 4, not 5, not 6. I could keep going on, but 34 counts were given. So the opinions of these people who were not juries is not what we do in this country. In this country, we have a system in which jurors decide who is found guilty, and if you have a problem with that, you go to the appellate court, which the last time I checked, he was raising money so that he could go to the appellate court and appeal his decision, and they will have the final say so. Thank you so much.